In Karen Reed's civil case, a lot of people are saying, oh, the two bars that were sued by the O'Keefe family, they'll probably settle out. The bars shouldn't even think about settling out, and here's why.
You lost. And you know what you did.
I'm attorney Andrew Myers. This is About the Law. Joining me, Yoli Medina from California. How are you, Yoli?
I am fine. I'm in a different setup here, so bear with me.
Well, you've got some art behind you. Looks nice.
Yeah. I'm attending a wedding, so I'm at a relative's home, so.
Oh, okay. Well, good luck with the wedding. That always
Later.
sounds fun.
Yeah, later.
So what do you think about this? You know, people are saying, oh, well, in this civil case with Karen Reed, a couple of weeks before we're recording this episode, Karen Reed's new attorney said they're going to bring in maybe as many as 10 different parties in a civil rights case and all kinds of other stuff. And some commentators have speculated, it'll get simpler. They'll probably settle out with the bars. What do you think about that idea?
Well, I mean, I think if the bar if there has to be an agreement, right? I mean, I don't know if the O'Keefes would agree to a settlement, but presumably if they did offer a settlement, they might, if it's a decent amount, or, they might. But it's kind of hard to prove a case against a bar for the wrongful death of someone, right?
It's very hard. I have done 2 dram shop defense cases and won both on behalf of the bars. So if the attorneys that are representing the bars in Karen Reed's civil case settle, they don't know what they're doing. And I'm going to tell you why I say that. They shouldn't even settle out. First, why don't we explain for our viewers, because I didn't know before I went to law school, what is a dram shop? A dram shop is what we call a case against a tavern or a bar or a restaurant or any civil establishment that serves liquor. You go into a bar, something horrible happens, and people sometimes say, well, maybe the liquor establishment has some liability. It's a controversial issue, and the law has evolved quite a bit in recent decades, which is fast for the law anyhow. So that is what is meant by a dram shop. That is what is meant by a quote unquote dram shop piece of litigation. And I know that's pretty universal. That's what we call it up here in New England, and I'm sure they call it that in California.
Yeah.
So again, I have represented a bar in 2 cases and won both of them. And I'm going to go through both of them and give you citations so you can check my work and not think, oh, Myers doesn't know what he's talking about. In the first case, Joseph Albert by his guardian et al. By Harold F. LeClaire Company, Lowell, Massachusetts Superior Court. It's actually the Middlesex County Superior Court in Lowell, and there are these citations where you can find reference. And in case people think, A, that we're violating confidence or attorney-client privilege, 1, my clients have long ago allowed me to talk about it. But 2, this is a published case, and you can find it. And it was a case for injuries by an injured patron against the tavern. So like I said, the facts are a little bit different than the Karen Reed case, but there is reason why they can be compared, and I'll get more into that. It was a case for injuries by an injured patron against the tavern, and we tried it in the Middlesex County Superior Court in Lowell, and we got a jury verdict in favor of the bar, and it took them 3 hours.
And were you co-counsel, or did you do
Yes.
this one on your own? You had a
Yes.
co-counsel? Okay.
Yes, I was co-counsel with an excellent attorney in Lowell by the name of Robert Carnevale. It was his client, and he asked me to come in and do a lot. Busy guy, very busy attorney. So he asked me to come in and, do litigation support and do, as you know, discovery is a massive thing. We did all kinds of depositions, requests for production of documents, interrogatories, and there were a number of different parties that, were involved in all of that. So,
And did they have video back in 2003?
No, No, that's
Yeah.
a distinction that I want to get into in a little bit. That's a distinction. Way back in 2003, there was no video inside the bar. That's one of the things that makes the Karen Reed case much stronger, because we have video in both CF McCarthy's and also the Waterfall. So that strengthens my position here.
Yeah.
Okay. The second case that we tried and won on behalf of the bar was Carol L. Westerback versus Harold F. LeClaire Company, Inc. And there's the citation in the 50 Mass App Court 144, 735 Northeast 2nd, 1256. Again, this was the facts are a little bit different, but I'll show you why it's all relevant in a minute. This was a case for injuries by an injured patron against the tavern. Both parties, both the injured person and us defending the bar, filed motions for summary judgment. The Superior Court granted our summary judgment in favor of the defendant bar. Then we went up to the Massachusetts Court of Appeals. They, in a lengthy decision that you can read if you check those citations, they upheld the summary judgment for the defendant. Then it was taken to the Massachusetts Supreme Judicial Court, and they denied the ability to review it. They said, no, appeals court was right. We're not going to review it. So in the end, the appeals court decision in favor of the bar, my client, stands to this day.
Wow. And the
Go ahead.
plaintiffs filed a motion for summary judgment in that case, which is kind of rare, in my opinion, but I don't know how it is in Massachusetts. It's usually
Well,
the defendants who file motions for summary judgment.
We thought it was rare too, but they were so confident in their evidence, and the damages were very egregious. Wasn't a wrongful death case, as in the Karen Reed case, but the damages were awful. And so they felt they had a great case based on the case law, but it didn't. Good attorneys on the other side. I've got to say there were good attorneys on the other side. We remained in touch for a while after. And so in any event, something that is really important to understand in any dram shop case, in any case where you are going against the bar, is how do you get the evidence that the person was, in the vernacular, overserved? So now in the Karen Reed case, Hannah Knowles, a forensic scientist at the Massachusetts State Police Crime Lab, reviewed Karen Reed's medical records from Good Samaritan Medical Center to determine her blood alcohol level. So as you know, your blood alcohol level that's taken many hours later is not pertinent really directly to your blood alcohol level earlier when alleged events took place. So the concentration that was taken at Good Samaritan Medical Center translated to a blood alcohol content of between 0.78 and 0.92, Knowles said. The legal limit to drive in Massachusetts is 0.08. Knowles said she determined Reed's blood alcohol level was between 0.14 and 0.28 at 12:45 a.m. on January 29, 2022. That's the time that in one of the timelines, on one of the many morphing timelines by the Norfolk County District Attorney, they claimed that events occurred. And so this was done by this process called retrograde analysis. During questioning by Reed's attorney, David Yannetti, Knowles said she had no direct knowledge about the reliability of the results from Good Samaritan's Lab. So that's an issue anyhow to begin with. And that's something that the defense attorneys in the Karen Reed civil case have in their favor.
And I
Because-
don't recall, Andrew, I don't recall if did they bring somebody from the Good Samaritan lab to testify about the lab test? They did? Okay.
Yes, they did. And the person that testified was kind of torn apart on the stand by Eliza Little, because the hospital itself, they're there to do blood tests for medical reasons. If one of us has to go to the hospital and we need a blood test for some health condition that our primary care physician once looked into, that's what the hospital does. And on the stand, Eliza Little got them to admit that no. That's a good question. No, they're not set up to do blood tests in a forensic environment.
It's interesting.
So what is retrograde analysis? How can you take someone's blood alcohol level, sometime later, 8, 9 o'clock the next morning, and go back to the evening before? First of all, the courts in Massachusetts don't accept it unless there's some other corroborating evidence. So the bars have a lot in their favor in these cases, and the Karen Reed civil attorneys on behalf of the bars shouldn't ever even think about settling the case. It would just be stupid, and this is one of the reasons. What is retrograde analysis or retrograde extrapolation? It is a scientific method used to estimate a person's blood alcohol concentration, or BAC, at a specific earlier time. The technique is often used in liquor liability or drunk driving cases to determine the BAC at the time of driving, rather than at the later time of the blood test. By understanding how alcohol is absorbed and eliminated by the body, experts can make educated estimates of past BAC levels. Expert testimony is absolutely required, most often from a toxicologist who calculates the rate at which alcohol is metabolized by the human body. By knowing the time elapsed between the driving incident and the blood test and the correct BAC, experts can estimate the BAC at the time of driving. This method requires precise data and an understanding of individual metabolic rates, making it a complex but crucial tool in cases involving liquor and driving. Now, why is that important? Because we all are different. Our bodies are all extremely different. We all metabolize very differently. I mean, somebody, how do I say this without, being rude? I mean, someone who's larger, their body may metabolize things slower. Somebody that's smaller may metabolize things more quickly. We all know kids and young people metabolize things more quickly.
Yeah. And Karen Reed is tiny. Well, I mean, she looks tiny. I don't know.
She's a woman of slight composure, but this is something that anyone that does this would have to take into account. But there's more medical conditions, and I'm not violating anybody's privacy here, as maybe some police officers have in the past, but Ms. Reed is known to have medical conditions, and that is absolutely something that is looked at in a retrograde extrapolation. What kind of medical conditions do they have? Have they had issues in the past? What are their issues at that time? So that's something that absolutely goes into it. And again, this type of evidence is not allowed in the Massachusetts courts unless there's some other evidence. Well, what could that other evidence be? Eyewitness evidence, or, as you pointed out correctly, video evidence, which was not in existence way back when I was involved in these two cases. It just wasn't there. But now, as you know, there's video everywhere. You can't do anything without being on video, and such was the case in the Waterfall and CF McCarthy's. So I believe we have one more thing to take a look at, and that is, I thought it highly relevant, even though the facts in the cases that I handled and the facts in the Karen Reed case are different. Let's take a look at the BAC. Whoever did this slide said BOC, but we'll have to talk to them after this.
That would be you.
The next morning, Karen Reed's blood alcohol was said to be at point. This is when they took the test in the hospital, Good Samaritan Hospital. Her BAC was 0.14 to 0.28. Well, the two cases that I handled that I gave you citations to, and you can look it up if you don't believe me, the cases that went for the bar, the next morning the BAC was 0.048, way more than Karen's. And in case number 2, it was 0.248, way more than Karen's. So now, if we look at the relevant retrograde analysis tests, they allegedly said that Karen's BAC would have been at the relevant time 0.078 to 0.092. There's always a range. There's always a range because you can't know this with precision. I had an excellent toxicologist on the stand in this case, and he had testified in many, 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 many other cases. And even he said, no, there's got to be a range. So in case number 1 that I handled, the retrograde analysis would have had the person's BAC at 0.15 to 0.25. Way more than Karen's, excessively higher than Karen's. And we got a judgment for the defendant. In case number 2, we never really got into the retrograde analysis.
Yeah,
So
that was
that's-
case number 2 was the one with the summary judgment, right?
Yes.
Okay,
Yeah, so we didn't need it. We never actually had to get that. The 0.248 was pretty awful enough.
And just so viewers
yeah.
understand, so that the viewers understand, the motion for a summary judgment is when a party files something and they present enough evidence to show that the claim cannot go forward. And it's usually the defendant that does that because they're the ones defending, that they put evidence, that the claim is not it's not a valid claim. And then the other side gets to oppose the summary judgment saying, yes, it is. But usually it's the defendants. The plaintiffs usually don't bring motions for summary judgment because what would they, they're trying to, they would need a trial to determine it. So it's kind of weird that the plaintiffs filed a motion.
But they did. No,
yeah.
you're absolutely right. And I think that it was a good idea that you had to explain to our viewers, because everybody thinks that everybody is entitled to a day in court. And they are. But sometimes when a Rule 56, which is the rule for summary judgment, when the Rule 56 issues come up, what the filing party is saying is, even under undisputed facts, there might be, what color was the light, when did they go to the bathroom? Those facts are not genuine material facts. What a motion for summary judgment says is, under the undisputed genuine material facts, there's no dispute. And so therefore, as a matter of law, we're entitled to judgment as a matter of law. It doesn't go to the jury because the jury's function as the fact finder. The jury's job is to find facts. And if the genuine material facts all line up properly, there's no jury function. So that's basically what it says.
Yeah, that's a good way to put it. Yeah. So, I always think people understand what I'm talking about when I'm talking about motions. And a lot of times they're like, huh? And because, they're engineers or they do other things. And they're not.
If you're defending, you want to bring a motion for summary judgment for a lot of reasons. One of them could be a practical reason. To try a case, one of the cases I'm talking about here, the one that went to trial, took 10 days. That's expensive. We had to go to court every day for 10 days. And that's just the trial. That's not the pretrial and the motions and all of that that's part of the legal process. So that's one reason, just to take a look at the cost of it. And second of all, the stress of a trial. Your client, the owners of a tavern or a restaurant, which was my clients, they didn't want to have to go through this. They run a business, and they felt that they weren't liable, and they kept saying, and this is in any context, whether it's a car accident or a medical malpractice or a products liability case. And I don't think motions for summary judgment are often won in the medical malpractice field, or am I wrong about that?
No, that's true, because you have to have an expert. And if you're a plaintiff and you're filing a claim, you have to have expert support. So if you're filing a medical malpractice case without expert support, you're going to lose on a summary judgment. But most of the time, almost all the time, when you file a case, you have an expert who or even two, one on the standard of care of a physician and then the other one on causation. And so the defense will bring a motion for summary judgment, and then the plaintiff in a medical malpractice will oppose it with their own expert. So therefore, there's a disputed fact. One expert saying one thing, the other expert saying another thing, and it's not for the court to decide who's right. It's just that there is a genuine dispute that the jury has to hear. And the credibility of the expert, is not weighed by the judge or anything like that. So it's fairly typical in medical malpractice cases that they'll bring it, but usually they're not won on summary judgment.
Because there are genuine issues of material
Yeah.
fact, as you just pointed out. The experts on one side say this happened, and the experts on the other side say, "Oh no, the doctor did everything right." So yeah, that is a genuine issue of material fact, and that's a really good example of it. So maybe the legal arguments are a little bit up there. Maybe they're not. But let's take a look at the evidence in Karen Reed's case and compare them to the law that we just went through. And what I want to do is take a look at the video from both bars, and we're going to start with the first bar Karen Reed and John O'Keefe went to, CF McCarthy's. And here's the video from the bar.
Could you explain to us what this is?
Yes, from left to right, it is chronological.
Now, what this is your Buchanan going through the video that they had, and I just wanted to establish that this is Hank Brennan putting law enforcement on the stand. So we're going to take a look at this in the best light for the law enforcement and the way that they presented it to the jury in trial number 2. Here's the bar. Here it is. There's John sitting with his 2-color top. Here comes Karen. She's walking in. There's John. Extends his arm.
Do you
hugs
recognize
her.
who's in that video?
Yes,
From left to right of people that you recognize and identify the clothing they might be wearing?
from left to right, it'll be Mr. John O'Keefe wearing the gray sweatshirt that was displayed earlier, and then the defendant, who he is trying to embrace with one arm there.
So, okay, admittedly, this is early in the evening. This is the first bar early in the evening, but Yoli, do you agree with me that Karen walked into the bar perfectly fine? She didn't seem to have any issue. Well, there are a lot of people standing around, and she had to navigate her way around that and the wooden rail. And wouldn't you agree that there's no problem here?
No, she just looked fine.
Yeah.
This-
So we're not going to play the whole thing because it goes on.
I do not know who the other individuals are in the shot.
Okay.
All right, thanks, Yuri. Thank you. Now, to be true, this shows that she had a fair number of drinks that night. But there she's standing there talking. She's standing there talking. She looks fine to me.
Yeah, I mean, she's not wobbling, you
Yeah.
know. In other cases, we've seen videos of people who you can tell had a lot to drink, but this doesn't look like it. Well,
Yeah,
and
she's
you can't
standing-
see her face. Well, there. Yeah,
She's
she's not-
talking. She's smiling. She's talking. She's not falling down. When a minute ago somebody walked by her behind her, she didn't brush into them.
right.
Again, admittedly, this is the first bar, but as you're going to see in a minute, this is the most clear picture we have of Karen Reed the night of January 28th of 2022. She's talking to this other guy. Who knows who that is? I think at some point he was identified, but that's not relevant for our analysis here. This is just showing our viewers and asking them as the jury, now that you know the law, that the jury would be told that a bar is only liable to the extent that they serve someone who is showing outward signs of intoxication. So that's why this was shown to the jury. And I would be fairly certain that in a trial of the civil case, they would, and look, she's fine. She's not bumping into the guy that goes behind her. I mean, I would think they would show this. I would think the bar would show this. Look, if we serve this woman, she's displaying no outward open signs of intoxication. Look, she's using her hand to make a point. See that? She's showing one finger. I'm making a point here. Who knows what it is? So I want to fast forward. So I guess Hank ran out of questions. You know, somebody's going too close, so she pulls away. She doesn't fall down. If she was really inebriated, she could have fallen down.
Or you would see her moving, kind of, that kind of thing, moving like not being able to stand still, and she seems okay. And
So
that's
she has
one
to
of the
navigate.
things that lay people can talk about is whether they appear drunk or not, or inebriated.
Yes, you don't need an expert. What you're saying, I think, is that lay people are allowed to testify only as to their observation of facts. They can't testify as to their opinions. But this is deemed to be in the common knowledge of the layperson, and this is an exception to that rule. Where, yeah, I mean, most of us can tell if somebody's drunk. She's
Yeah.
talking. She's moving her head back and forth. She's having a pleasant conversation. And by the way, I have the volume turned up, so Hank has nothing to say here.
So, well, we can't hear her, so we don't know if her words are slurred or anything, but she looks fine.
Yep. Again, this is the first bar, but let's take it all the way to the end. There she is. There she is.
Mr. O'Keefe on his cell phone again?
Yes, he is.
Okay, she decided to sit down. I don't think that's relevant at all. I think we'd all rather sit down after, she's been in this bar for a while, which is not relevant in terms of the determination of liability against a dram shop.
Yeah.
Most of us, when we go out to eat or drink, sit down, don't we?
Well, yeah. I mean, it doesn't look like she's arguing with anybody.
Look at that. She's standing up.
They're laughing.
I was going to say she wasn't leaning on anything, but she contradicted me, and there she is kind of leaning on that. But that's okay. I mean, a lot of the time she is standing up okay.
A shot glass is picked up by one of the patrons, and the defendant retrieves it from him and places it back on the bar.
Okay, thank you, Yuri. I never thought I would thank Yuri Buchanan for helping me to narrate the podcast, but there he is. Okay, I want to go forward to when she leaves the bar, because that is something that's very relevant. You would think if there was liability against bar number one, CF McCarthy's, you would think that we would see some outward manifestation of intoxication. And Yoli, correct me if I'm wrong, as you always do, and it's okay. I don't see any outward signs of intoxication here.
No, I see. I see her chatty. Some people when they drink they get chatty, but I don't see her as. I wouldn't say she's drunk. No, not at all.
Come on now, Yoli. I know people who are chatty when they're stone cold sober.
What time are we at now?
True.
That was 10:34, so we're moving to 10:37.
What is the drink on at 10:34?
That is 5 drinks. Yep.
Let's get her leaving. Let's get Karen leaving. She's still doing all right, in my book. I don't know.
Yeah.
Okay. They're getting ready to take off. Look at her. She's walking out of the bar.
And
They're walking
two
out of the bar
walk
together.
out of the bar without the beverage in their hand being deposited anyway.
Now, John was blocking her a little bit, but I don't see her having a problem getting out of the bar, do you?
I don't know.
There goes John.
Yeah, she
There
just
she
walked
goes.
out. Yeah.
There she goes. He kind of tapped her in the side, and they walked out. And that's the first bar. And I try to be objective in these things. I'm not a member of the club. I don't go to the events. I didn't go to the Wilbur. I try to be as objective as I can possibly be, and I, for the life of me, don't see any signs of intoxication in bar number one. Granted, we're going to look at bar number two in a minute.
Yeah, I don't see objectively that she was drunk. Somebody who knows her might might say that when she drinks, she talks a lot, and they'll say, "See that shows she's drinking," but not for a bartender or a bar. I mean, she's fine. You know what I mean? She's fine.
I'm going to go out on a limb and say, one, like I said before, a lot of people are chatty whether or not they've had anything.
Yeah.
And two, I think she's a chatty person. Now,
She
I may have gone out
probably
on a limb. I might get negative comments down there, but I think she's a chatty person. I think she likes to talk. But
Yeah. Yeah.
It's-
And the standard is objective. Objectively, I don't see her as being drunk, because we have seen videos of people in other cases where, you know, they look a little inebriated and they're kind of swerving back and forth and that kind of thing. And she doesn't show that.
no. So what I'm doing now is I'm trying to
Court's
bring
permission,
up
I'd
the
like to
second
display parts of it.
the second bar, and the second bar is the waterfall, and the video is kind of foggy and it's hard to tell. And the way it was presented at trial number 2 was prosecutor Hank Brennan brought it in through Jennifer McCabe, who was there, and she and he are going to narrate through this.
Exhibit 22, which has already been introduced into evidence, which is video surveillance footage from the waterfall.
Okay.
I'd like to start at 10:54:20, please.
So thanks, Hank, for editing this. We're not going to show the whole thing. They were there for quite a while. It will take us quite a while. So Hank and Jen
Stop
kind
for
of
1
walk
second.
us
Do
through
you
this.
recognize what's in that video?
Yes,
And what is that?
that is the waterfall.
Timestamps at the top there. Timestamps at the top. January 28th, 2022. This is 10:54:28 according
Do
to
you
the
see the 2 people
timestamp.
entering from the left?
I do.
Do you know who they are?
I believe that is Miss Reed and John O'Keefe.
It's kind of hard to
Is there any way
see, but you can
enlarge
see.
the top of the video where the other people are closer to the table or bar? No. Okay. Looking at this video, can you tell or identify anybody under that timestamp? And if you can't, that's okay, but if you can you tell us who you see?
I think the guy right there, well, where she just is Brian Higgins.
Okay. If you could go up a little bit, Ms. Gilman.
I believe that's my husband, Matt. And
the
then
right?
on the right, and I think that's me on the left.
Okay. And if you can go down the table to the left, Ms. Gilman. You recognize who that might be from the clothing?
I'd have to take a guess that
Okay,
it
but
could,
don't guess. It's
Okay.
okay if you don't. Anybody else at the table more to the left do you recognize?
not from this picture.
Ms. Gilman, could you highlight where Ms. McCabe thinks that she is on that video with that circle you just had and play the video?
So one of the things about this video, Yoli, is that it's murky. It's foggy. And that's been one of my pet peeves as somebody that did work in the media for some time. You know, even in 2022 when this happened, the technology was there for a clear camera to take clear. I've had cases where I've gotten video going back into the late teens, and it's been pretty clear. So why even have video if it's not going to be clear? But number two, when we do see Karen, and we're going to see Karen and John in a minute, even at the lower burden of proof of by a preponderance of the evidence, which, as we've talked about before, is way lower than beyond a reasonable doubt, even at the preponderance of an evidence standard, where the O'Keefes faced the burden to show that Karen was exhibiting outward signs of intoxication, if they've got blurry video like this, that's why I spent so much time in the waterfall, because that's pretty clear. Their video was pretty clear, and there's no signs of outward intoxication. Okay, you say that she was chatty, but I say, so what?
Yeah, it was at the waterfall. This is the waterfall, right?
Oh, did I misspeak?
I
Yes,
think,
this
yeah,
is the waterfall.
this is the
Did
waterfall.
I misspeak? Okay, all right, yes. The earlier bar was McCarthys, and to be very clear, unlike the video, this is the waterfall.
Yeah, it's like the lens is dirty or something.
Can't be that much smoke in the bar. Can't be.
You could stop. Is that you clapping, Ms. McCabe?
Yes, it is,
Why are you clapping?
because I was happy to see them.
Both of them.
Yes.
Okay. Could you continue, please? And who's that person walking right to left hugging people?
That is John O'Keefe.
And that's Karen.
Continue, please, Ms. Gilman.
Now, if you're trying to prove that somebody is showing outward signs of intoxication, the first issue is this is so foggy that if there were such signs, you wouldn't see them. But second of all, even kind of squinting my eyes into the
I know,
monitor,
Yeah.
and I viewed this on a much larger, I have a much larger monitor in my office, and I viewed this there, and it's just not there. It's just, it's just not there. Now, it's true that this video is
Are you
known
interacting
for
with
the,
anybody?
I can't see where I am.
Okay. If you could stop the video, please. Could you move ahead to 11:26:50, please? Is that your group still at the waterfall?
Yes, it is.
If you could stop there, Ms. Gilman. If we could hone in or circle where you were previously, where we saw Ms. McCabe. I know it's a bit blurry. If you can, and if you can't, please let me know. Can you see whether you're in that area?
I believe I am, yes.
Could you put the circle down just a little bit, Ms. Gilman? Okay. If you could play from 11:26:50 to 11:27, please. We're a little bit ahead right now. Who are you hugging there?
I believe that's Miss Reed.
Thank you.
she believes it's Ms. Reed, but you need more than that, even to meet a preponderance of the evidence standard. Am I right?
Right. I can't see any. I mean, I'm trying to look. I just see kind of shadows, but you can't make anybody out. So if she says she believes it's Miss Reed, it's like, is it Miss Reed? Yes or no? You know?
Exactly. Give me a yes or no. Don't give me a let me say this about that kind of an answer. It's just, it makes. Now, on the one hand, there is enhancement video. There's video enhancement programs, but had the Norfolk County District Attorney done that to this, they would have gotten even more grief than they deservedly got. But it is what it is. I hate when people say that, but it is.
Move forward to 11:46.
Clears up a little. The band's packing up. The band's packing up to go.
Yeah, I don't know what this shows exactly,
You
but
pause, Ms. Gilman.
they're drinking.
Could
Okay.
you circle in that same area where Ms. McCabe was last describing? Can you make anything out in this video?
Yes, it looks like they're all, toasting or doing a cheer before they do a shot.
Can you see whether or not the defendant's in that part of the video?
Yes, it looks like she is in front of the man in the plaid coat.
Right there. That's her
Were you
right there.
participating with the drinking at this moment?
I don't see myself in the video. I don't believe I was.
But you were drinking separately that night, weren't you?
Yes, I was drinking beer.
You can continue, please.
That's Karen right there. And to the extent you can tell anything in this blurry video, she's just sitting there. She's not
Right.
falling off the chair. She's not trembling with her glass. Nobody's holding her up. I mean, to the extent that, go ahead.
The video is just not good quality to tell anything really. I mean,
I would
It's-
agree with you, but I would also take it one step further and say where you have the burden of proof, even by a preponderance of the evidence, I would agree with you fully. You can't tell anything from this. This means nothing. This is meaningless. This is not evidence that this bar, I have to keep checking because I get them confused. This is not evidence that the waterfall served her while she was exhibiting outward signs of intoxication. And a judge, if this goes to trial, and I'm telling the attorneys for the bars, you're wimps if you settle this case because there's no evidence against you. You're really wimps if you try this case or if you settle this case and don't take it to trial, because this is no evidence where a judge will specifically instruct the jury, as I've heard them instruct them, that you need to find, in order to hold the Waterfall bar liable, you need to find that they served her intoxicating liquor while she was exhibiting outward manifestations of intoxication. And it's just not there. Okay, that's the end of this video, but I will represent to you and to all of our viewers that this is the clip that Hank showed to the jury in case number 2. And he didn't show them walking out. And I will represent to you that in that video, the full video, which is available online, she and John walk out fine. They walk out. They walk from where they are in the back there across that wall to the left of us where the band was, and they just walk out. Nothing of note. Nothing absolutely of note that they were staggering or holding on to the benches or the walls, which I've seen people do, by the way. They just walked out like they had gone to the mall and bought a new purse and walked out like, okay, all right, let's go home now. So I will represent to people that is what the video shows. In my view, there's really not a lot to see in either of these videos. Definitely the video from CF McCarthy's, which is clear as a bell. There's no signs of intoxication there. And there's nothing that we can see in the waterfall. Now, I know people will say, well, she admitted it.
She,
You know,
well, she didn't. She admitted she was drinking, right?
and driving, yeah. And
Did
she
she admit she was drunk?
yeah, well, that's all. Now, the words are very important. I think my memory of the clips, and we're all confused because Hank did not present the videos of her interviews in any logical, chronological, contextual order. He just kind of threw them up there. But based on a comment that she did make, I believe, I wasn't in the jury room, but I did listen to some of the jurors. I believe some of the jurors felt that based on her comments, that's why they convicted her of OUI. But I mean, the evidence and what you see in your eyes is important. And based on the law that I went over earlier in this episode,
See it.
I don't see it. I don't see the evidence that's required for a conviction in Massachusetts. So
No,
think
I suppose they could have a witness who was there say that she was, slurring her words or something like that. But even then, that doesn't put the bartender or the bar on notice because the bar is not necessarily having a conversation with her.
Well, that's a good point. Before we went on, I was reviewing some of what two of the people that were with them, Karina Kolokaitis and Mike Camerano, and I didn't see that they said anything that was of an incriminatory nature of her looking like she was intoxicated. And that if either of those witnesses who went on the stand had seen something like that, Special Prosecutor Hank Brennan would have mentioned it. You know that. You know that he, would have gotten any witness testimony that showed that she was intoxicated or exhibiting signs of intoxication in the bar. So
maybe they get out on summary judgment. Maybe the bars bring a summary judgment motion and gets granted and they're out.
I'm just saying that they're being wimps if they offer a settlement, because a settlement, and it's been said that maybe there will be a settlement because that would give the O'Keefe's attorneys, some money to pay for the experts that they are in fact going to need. Maybe it will give if this happened, this would give the O'Keefes money that they'll need to pay the lawyers to keep going, because they just brought in this new attorney from California. And as we sit here doing this episode, we do not know what the arrangement is financially for the fee, but it's kind of hard to believe that, she would come all the way from California in a case like this on a contingent fee. I find that hard to believe. I wouldn't, but that's just me. Would you? Would you come all the way here to Boston to try a case on a contingent fee where the outcome was questionable?
No.
Okay.
No.
I rest
wouldn't.
my case. No, I'm just kidding.
No, I wouldn't do that. And but there might be other reasons why she got involved in the case, and depending on what, if it's maybe the publicity, I don't know. I don't know anything
know.
about her, so I
don't either.
I can only speculate, but the bars are going to be a hard one to go after. That's for sure.
I think so. That's the purpose of this episode. But before we sign out, why don't we take a look at some viewer comments? And we got some great viewer comments this week. And they're basically taking a look at the case in which the civil attorneys were arguing. This is number 5, JoJo Big Sister. Hey, JoJo Big Sister, thanks for your comment. They were going to pin this case on Lucky. Plow drivers got radio calls at 4 a.m. That cop was hit by a snowplow. Then they discovered that Karen Reed had a cracked taillight, so pinned it on her. I don't remember that, but if you've seen it, let me know. When a driver came in from plowing and asked about radio call for clarification, he reported to the others that he was told, forget it. Don't mention it again. If someone asks you again, they'd be unemployed. No, I don't know, Yoli. I don't remember that, but
I don't. I think Karen Reed might have stated something like, could a snow plow have hit him or something?
yes, she's the one that said that, but
Yeah.
it wasn't they. This comment implies that the people back in the shop or the McAlberts,
Yeah.
or whoever. That's what this commenter is.
I
is
don't remember
talking
that.
about. I don't either.
This is from Linda Wade, 4OK 639. When your own police union drops you and will no longer defend you, those texts and that man's behavior as reflected in those texts must be pretty damning.
Yeah, this goes to Michael Proctor. He's trying to get his job back, and hearings were coming up wherein he was going to be defending himself, trying to get his job back. And just days before that, the Commonwealth dropped a notice saying that, yes, they did, in fact, have, from Michael Proctor's phone up in the cloud, they had his texts going back to 2013. And it was reported elsewhere that some of those texts included racist and homophobic comments. And the board at the union voted unanimously to just get the heck out of that case and to not defend
God.
Mr.
What an
Proctor. So
embarrassment.
what an embarrassment. So that's what that comment's all about. Number 3 is from Irish Outsider. I think in the public interest, all of Proctor's messages, less private messages with family, should be made public. I believe there is a deep-rooted corrupt culture within the Mass State Police and incestuous relationships with the DA offices throughout the state, not just Norfolk. His texts will be a window into that culture.
That's interesting. That's a good comment.
Well, there's been a story in the news in Greater Boston the last couple of days where there are questions and allegations swirling against 3 district attorneys' offices in Massachusetts,
Yeah.
not the least of which being Suffolk, which is Boston.
Yeah. And this is from Judy F6220. Dance like no one's watching, text like federal prosecutors are reading.
Do you know what my comment was to this? And the third rule of thumb is never say anything online you wouldn't do in the middle of the day in the middle of Main Street in your town.
Yeah.
Because, you're not alone when you're sitting in that little dark basement or wherever you are with your little computer. It's all, as Mr. Proctor just learned, they can pull it down.
That's terrible.
Okay, number one, Ms. Holmes says the Commonwealth is so indignant and the ridiculous spouting off that they reviewed Proctor's texts, etc., and they have decided which are exculpatory. The fox guarding the henhouse. Exactly.
Yeah, those are all good comments.
We get some good comments. This being a legal true crime channel, we get people that think and use their heads, and the only ones I always mention at the end of these episodes is that I do like intelligent comments that make you think and that fit on one index card here, because the ones that go on really long are hard for me to read and they're hard for us to, get on an index card. But we really like it when people have positive comments instead of saying, that someone's a moron or calling them a name, which any fifth grader can do. No disparagement meant to fifth graders. Start a new thread and tell us why you feel the way you feel. Tell us, what facts you've read, what law you know, what you've seen somewhere else. And that's fine. That's fine. And we love that. We love that. And so I guess that brings us to the end of our episode. We always ask people to like and subscribe. And I always also, before we go, and I ask you for your final comments, I'll give you a minute. I always put you on the spot and ask you your final comments. But before I do that, I'll give you 30 seconds to think, Yoli. And we will have two of the characters from the Karen Reed case ask you to please subscribe to our humble podcast.
Do you pay for a subscription?
I do not.
Ask it differently. I'm going to allow that.
Well, you know now because you follow. Do you pay for a subscription?
I do not.
Did you get one for free?
Yes. I was not paying to any social media.
All right, Mr. Brennan.
Sorry, I have just a few more questions.
It's denied.
I was not paying to any social media.
Okay.
And as well, you don't need to pay to subscribe. A lot of people sell you merch, and that's okay. That's fine. Buy their aprons and their coffee mugs. Support them because we like, diversity in the YouTube sphere. But, we don't ask you for any of that. Just go down in the bottom and subscribe. So, Yoli, now that I put you on the spot and gave you 30 seconds, what are your closing thoughts?
My closing thoughts are that you made a good point about possibly settling with the bars so that they could fund the lawsuit against Karen Reed. That was a good point. That might be one of the strategies. I don't know. But as you say, it's going to be a hard sell to try to get the bars liable for what happened.
Based on Massachusetts law and my involvement in two cases of note with horrible injuries, I must say, and the facts were different in those cases, but based on my understanding and study of Massachusetts law and my involvement in the two cases, the bars are crazy to settle out and pay 1 cent, and the lawyers are wimps if they allow it, although a lot of times it's the insurance company. The
Right.
insurance companies really don't care about anything. They do a cost-benefit analysis, and so they're calculating right now, how much is this going to cost? Deposition, let's see, we're going to have to do interrogatory. It's going to cost, X, Y, Z. Yeah, give them money. But insurance companies, and there are books on this, insurance companies like to delay, deny, and defend.
Yeah.
There's another book by another insurance company. I was going to inject an adjective, but I'll leave that out. There's another one called From Good Hands to Boxing Gloves. That insurance companies really, they want to just, throw logs under plaintiff's attorney's feet. I've had logs thrown under my feet for 30 years now, but, in this case, I would think they're crazy to settle this one.
Yeah. I can see, but I mean, I can also see what you said, the insurance company wanting to throw money out there just to get rid of it.
Yeah,
Yeah.
let us know what you think down in the comments. Let us know what you think in the comments. Should they settle the case? Should the bars settle the case? The Waterfall and C.J. McCarthy's? A, should they settle the case? B, will the stubborn insurance companies settle the case? I don't know. For an emoji, I got an emoji. If you have been with us for this whole episode, I would suggest the emoji. Do they allow beer bottles or liquor? they allow
Yeah,
that?
there's emojis of little beers and mugs, and little wine glasses and martinis.
Because I know there are rules. I've only been doing this for like 2.5 years. I've only been doing it for 2.5 years. But boy, oh boy, have I learned there are rules. And if you go afoul of those rules, oh boy, you're in YouTube jail.
Yeah, no, I think they're allowed, the
Okay.
little emojis.
Yoli, thank you.
Thanks.
Thanks everybody for being with us. Have a good one. Whether you are in the grocery store, the gas station, or anywhere else, please remember to be kind to people. You don't know what they're going through. And the same goes for our comments section. We want you to comment, but be nice, be kind, be positive if you can. And thank you for watching. Be sure to like and subscribe. Have a good one.